jump on it. If you sexed and flown it, if you freak dead and own it, don't brag about it, come show me. Come on, dance, jump on it. If you sexed and flown it, well, it's Saturday night and we in the spot. Don't believe me, just watch. Come on. Don't believe me, just watch. 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 Don't believe me, just watch.
Please enter your access code, followed by the pound. That entry is not valid. Please enter your access code, followed by the pound sign. Thank you. Please stand by. You will now be placed into conference.
This only happened since fall last year. This started. Who's on the line?
This is Bailey Wolfstead from the DA's office.
Okay. Thank you, Ms. Wolfstead. Who else do I have on the line?
Morgan Griffin.
Yeah. Thank you, Ms. Griffin. And anybody else on the line? Somebody. There's 4 beats. No. And who just joined the line?
This is Probation Officer Herman.
Okay, thank you. And who just joined the line?
Miss Kemp.
Okay, thank you. And who just joined the line?
This is Miss Gibson.
Okay, thank you. Oh, they're not on public comments either, right? You should be. They didn't answer. No. Maybe they're waiting until the last minute, make it suspenseful. Okay, so I have Ms. Wolfstead, Ms. Kemp, Ms. Gibson, Ms. Griffin, P.O. Herman. Is there anybody else on the line? Oh, there's the jail.
We're still waiting for the inmates to show up. We're just getting activated here.
Okay, thank you.
And question for you?
Yeah.
We have another phone in here that is supposedly so the inmates can talk to their attorney.
Oh, great.
The question is, how's that going to work? Is there enough for them to call, or is the attorney going to call on this phone, or we're just going to deal with each one as it comes?
I think we'll just deal with it as it comes, but is there a direct number there that we could just give to Ms. Griffin and them, and that way if they need to call, then they'll have the number?
You ready?
Yep.
465? 4374.
Perfect. So when when they call, my suggestion to you is that you would have to mute your end so that the conversation isn't public, but that phone is still called into the conference line.
You alright? Enjoying the sun out there?
Well, yeah. What will I do when they're talking to the attorney? I'll just mute this phone that you're on.
Oh, yeah.
Yes,
Whether
yes.
it's talking to the attorney, then we'll unmute it when it changes.
Okay, perfect.
All right, well, we'll see how it works. We're flying by the seat of our pants.
All right, thank you.
Yep.
How you doing, sir?
Not too bad. And yourself?
You're, top 3
We're all flying by
And who just joined the line?
Hi, Andy Miller at the Public Defender.
Okay, thank you, Mr. Miller. Did somebody else join the line?
Nick Pulaski.
Okay, thank you, Mr. Pulaski.
Adam Clerk,
Uh-huh.
and we have all 4 1080s here, or all 4 inmates.
Perfect, thank you.
Yep.
And who just joined the line?
Brock McCourt.
Okay, thank you. I don't know. Who else just joined the line?
This is Macaulay.
All right, Superior Court for the State of Alaska. Judge Amy Mead presiding. Please be seated. I left the list that you gave me on my bench. Thanks. All right, thank you. We are going to start with Mr. Hutter. All right, 1JU19554, 1JU2339, State of Alaska versus Mark Hutter. Mr. Miller, are you on the phone?
Yes, Your Honor.
All right, and which DA is here for Mr. Hutter?
Bailey Wolfstead.
All right. Time set for a change of plea. Mr. Hutter's appearing with Polycom. Mr. Miller, why don't you tell me what the Rule 11 agreement is so I don't have to decipher your handwriting?
And Your Honor, this is something that's been also worked out with Mr. Pulaski, and actually, he had more to do with it than me, and I want to make sure I get it right. So,
Oh, wait, do we have Mr. Pulaski on the phone? Because you represent Mr. Hutter on the probation case. Do you not?
Yeah, is Pulaski on the phone?
I'm here, and it's not a probation case. It's just 19554. It's just a case.
All right, thanks. All right, go ahead, Mr. Miller.
okay, so what I have for Mr. Hutter will plead guilty to attempted tampering, which I believe is, I'm not exactly even sure what's charged. That's Mr. Pulaski's case, but it's a reduced charge, attempted tampering in 1JU1900554CR. He'd be sentenced to 30 days flat. In my case, which is 1JU2000339CR, he'll plead guilty, and this is where there was some confusion. Maybe Ms. Wolfstead can clarify. It's not count 1, it's count, I wrote count 1 on there.
Criminal trespass. Well, because
Criminal trespass.
Okay. Yeah.
Wait. Too many people talking at once. So, in 2339, he's pleading to the criminal trespass?
And unlawful contact.
And I believe it's both counts of unlawful contact, Mr. Miller.
And two counts of unlawful contact. So criminal trespass and 2 counts of unlawful contact. Other counts will be
Oh, it adds a count. Just
7 with that in.
Just a second.
It's hard for me to understand everybody with everybody talking. I'm just saying.
I'll repeat it in a minute. Wait a sec. I've got to understand what you're doing first. So, count 4, criminal trespass. Count 5, unlawful contact. And count 7?
Yes.
And what's the agreed upon sentence?
He will receive 30 days flat on count 7, and that'll be consecutive to the 30 days imposed in 1JU1900554CR. He'll receive 6 months with 6 months suspended on the unlawful contact in count 5. He'll be on probation for 2 years with conditions of obey all laws, no contact with BF, do not return to BS residence, obtain a substance abuse treatment assessment, and follow all recommendations, no controlled substances.
And what was the sentence that was going to be imposed in connection with count 4?
It's the same, Your Honor. So it's 6 months with 6 months suspended on that count as well, with the same probation conditions.
And just in case there's ever a PTRP, those counts, those were not running. Never mind. I got it.
Concurrent, consecutive.
It doesn't matter.
I'd like to make one other correction.
Go ahead.
which is he'll be pleading guilty to attempted hindering, and
Thank you.
I filed that with the court.
Thank you for that correction.
In 19554?
No, Your Honor. I'm sorry, yes, in the older case in 19554.
All right.
And I filed that amended charging doc.
And when did you do that?
Just before this hearing, so it should be in the 1JU inbox.
I got it at 2:33.
Hold on, I just need a copy of it.
I would like a copy of it too, all the paperwork, just throwing that out there.
Mark, I'll send you a copy of this in the mail, okay?
Okay.
If you want it in time for this hearing, I would have to move the hearing. Do you want to move forward without it?
No, I
No,
don't
he
mind.
doesn't want it for the... Okay, thanks, Mark. I was hoping you would say that. The issue there is that Ms. Wolstead had originally written attempted tampering, but then we got it squared away and it's attempted tampering. So I think that's the thing that Mr. Hutter is tracking.
The hindering, yeah.
This would be why. Did you find it? Okay, thanks. Thank you. All right, Mr. Hutter. And are the parties intending to go over with sentencing today?
Yes.
Why don't you go ahead and give me your sentencing arguments so that I can go ahead and do this all at once. Ms. Wolstead?
So you want sentencing arguments before we take the plea?
Yeah, I do, so that I can sentence him right after I take his plea without turning back. I've got 3 other people sitting at Lemon Creek.
Thank you.
Okay. Your Honor, I think this is an appropriate agreement. I'd request that the court accept it. I will let you know that on the one case that does have a victim, we did attempt to contact the victim multiple times. We did leave him a message with the change of plea, date, time, tried to talk to him about the agreement, but were unable to reach him. But again, we made multiple attempts, so I'd request the court find that we made reasonable effort. What I'll note is that Mr. Hutter and Mr. Flint are in a domestic violence relationship insofar as they were roommates at one point, but not insofar as the type of romantic relationship that's often considered with domestic violence. That Mr. Hutter was asked not to be there, was told not to be there. In fact, there was a court order, and he violated it. He scared Mr. Flint, and then once he was arrested, he made 39 calls or attempted calls to Mr. Flint from the jail. As far as the hindering case, that is a case where Mr. Hutter was hiding Christian Knapp, who has since passed on, as he was evading the police on a felony. There were certain legal issues in the hindering case, such that I think it's appropriate to reduce it to a misdemeanor. I think the sentence overall addresses Mr. Hutter's rehabilitation, as well as really one of the primary concerns, particularly with the new case, is deterrence of Mr. Hutter in contacting Mr. Flint and showing up at his home. Certainly a year hanging over his head, and if he shows back up, that year can be imposed, I think is an important factor there in terms of deterrence. It isolates him to an extent, addresses the community's condemnation, and I think overall meets the Cheney criteria.
Can you tell me what Mr. Hutter's criminal history is?
Absolutely, Your Honor. It's pulling up. Here we go. Nope, this is not Mr. Hutter.
Your Honor, he has a handful of misdemeanors, including refusal in 2019, disorderly conduct in 15, DCOR in 15, a couple of those, violated DV order in 12, DCOR in 10, failure to appear in 09, and a DUI in 08. So looks like about 8 misdemeanors between 08 and 2019. If he has some before 2008, I just didn't print that page, so that's what I think.
Understood.
And Your Honor, I finally just got mine pulled up. That is correct. The 2019 case is the refusal to submit to a chemical test. Before that, it was 2018 for disorderly conduct, violating release, violating DBPO, and 09 failure to appear, and an 08 DUI.
All right. Mr. Pulaski, you want to go next? And Mr. Hutter, I'm doing this so that I don't have to advise you about whether or not you can withdraw your plea if I don't want to accept the Rule 11 agreement. I'd like to know before I start. Go ahead, Mr. Pulaski.
Sure. Your Honor, I represented Mr. Hutter first in the 19554 case. In that case, I filed a motion to suppress evidence and dismiss indictment. It's sitting in your file. Unfortunately, it will never be looked at. I think the defense would have done pretty well on it. What happened is the police thought Mr. Hutter had Mr. Knapp inside the house, and they came to the door, and Mr. Hutter didn't want to let him in, and he said, I don't want you to come in without a search warrant. And then they presented him with this choice. They said, either you agree to let us in the house, and we won't charge you with a crime if Mr. Knapp is inside, or if we have to go get a search warrant, we're going to come back and search the house, and if Mr. Knapp's there, you're going to be charged with a crime. And so I think that, like, the consent to enter was not really appropriate in that situation where the police say, either you let us in and we are going to search your house and not charge you with a crime, or if you make us get a search warrant, we're going to arrest you and charge you with a crime. They never informed Mr. Hutter that Mr. Knapp was being looked for because of a warrant. They just said, we need to find Mr. Knapp, we need to find Mr. Knapp. I listened to all the audio. They never said the reason they were looking for Mr. Knapp. Eventually, Mr. Hutter kind of said you could come in. I think that he was saying you can come in because it was raining outside and it was on a tin roof and they couldn't hear. But then the police went in and Mr. Hutter was like, wait, you can't search my whole house right now. But the police went and searched his whole house and they found Mr. Knapp downstairs in the basement. I don't know that Mr. Hutter would have ever actually been guilty of hindering because there were 2 entrances to get into the basement, and Mr. Knapp was right underneath this one entrance. It was in the bedroom that he could have accessed and gone down there on his own. So Mr. Hutter could have just been aware that Mr. Knapp was in his house and not let the police in without a search warrant, which is his right to do. And Mr. Knapp could have accessed the basement on his own without any police assistance. There was a different entrance where Mr. Hutter would have had to have, like, covered the entranceway with a rug, but there were 2 entrances, so Mr. Knapp could have gone in the one that he was directly underneath when the police found him, which would have not required anything for Mr. Hutter to have done that. But then when the police, so the police took Mr. Hutter as having provided consent to enter his house and search his house, and then they found Mr. Knapp, and then they arrested him and charged him with a crime anyways. So the way they got their so-called consent was by saying, if you let us in, we won't charge you with a crime. He let him in. I don't know that he actually did, but, you know, they thought he did. And then they went in and then they arrested and charged him with a crime anyways. When Mr. Hutter had this case pending, you know, I did the motion, and then he came back to court in the case that he's now with Mr. Miller on, which is another felony, and then the prosecution made this misdemeanor resolution, which, looking at it, when you're charged with 1 felony and fighting it, you know, like, maybe you'll win. That's my case. When you're fighting 2 felony cases and you have a misdemeanor resolution to resolve everything, then you take that. And so we really appreciate the prosecution's offer. It's, you know, a really good resolution for Mr. Hutter. He's facing my felony and Mr. Miller's felony, and he's coming out of it with just misdemeanors. I've told Mr. Hutter that I was pretty upset with him that we didn't get to litigate the motion that I did. So he knows that, and he knows that I said I was pretty upset with him over that. But this resolution, the prosecution really made a tremendously good offer for him here. He's going to be in jail for a while. He's going to come out on misdemeanor probation. The stuff that Ms. Wolfstead said about how he just needs to stay away from this person, I think that other person mainly wants him to be away if he's using drugs or anything like that. I think that's the reason that other person wants Mr. Hutter to stay away. Not that he doesn't like him, but that he doesn't like it when Mr. Hutter doesn't make good choices. And I think that's what's at the heart of that more than anything else. But we appreciate the prosecution's offer. I think it's a good one. I think it's a good resolution for Mr. Hutter. So it kind of stings we didn't get to litigate it, but oh well. That's what I have to say, Your Honor. Thank you.
Mr. Miller?
Your Honor, I came into this case very late. Mr. Pulaski had done a lot of work with Mr. Hutter, and I believe Ms. Wolfstead initially thought that Mr. Pulaski was representing Mr. Hutter on the newer case as well, so she actually negotiated it with him. So mainly the one thing I did was write up that change of plea request. I don't have much to say, although I will tail on Mr. Pulaski and say we encourage you to take this, accept this agreement.
All right. So, Mr. Hutter, let's go back to taking your change of plea. In one case number 1JU 19554, the state has amended the charge to attempted hindering. Prosecution in the first degree, it alleges that on May 5th, at or near Juneau, you, with the intent to render assistance to a person who had committed a crime punishable as a felony, took a substantial step towards rendering assistance to that person who had committed a crime punishable as a felony, with the intent to hinder the apprehension, prosecution, conviction, or punishment of that person. It's an A misdemeanor under Alaska Statute 1156-77A1 and 1131-100. As an A misdemeanor, the maximum term that could be imposed is 1 year and a $25,000 fine. My understanding is that as to that amended charge and as to 3 counts in 1JU 2339, you intend to change your plea. Sir, do you have a good factual basis, a good understanding of the factual basis of the allegations in both of those cases?
Yes, Your Honor.
Do you understand, sir, that you have the right to continue to deny the charges? And if you did, the state would be required to put on a trial against you, at which they'd be required to prove the allegations against you beyond a reasonable doubt. You'd have the right at that trial to be represented by counsel, to challenge the state's evidence, cross-examine their witnesses. You could have me subpoena witnesses to testify on your behalf. You could testify if you wanted to. You're waiving the right by moving forward today. Do you understand that?
Yes, Your Honor.
Do you also understand, since there's a Rule 11 agreement, you would be waiving your right to appeal the conviction or the sentence, since this is a complete Rule 11 agreement?
Yes, Your Honor.
Has anyone promised you anything to get you to change your plea today, besides that Rule 11 agreement?
No.
Threatened you in any way?
No.
Are you under the influence of anything today that affects how you think?
No.
Do you think you've had enough time to talk to Mr. Pulaski and Mr. Miller?
Yes.
All right. So in case number 1JU 19554, on the charge of attempted hindering prosecution in the first degree, how do you plead, sir?
No contest.
And in case number 1JU 2339, on count 4, criminal trespass, how do you plead?
No contest.
On count 5, unlawful contact, how do you plead?
No contest.
And on count 7, unlawful conduct, how do you plead?
No contest.
Your Honor, the Rule 11 agreement was for guilty pleas. The state will not accept no contest pleas for the Rule 11.
Hey, Mr. Hutter, she's actually right about that. If you've ever done a no contest plea in a city case, the city allows no contest plea, but not the state. So
okay,
that's probably what's going on.
All right, so Mr. Hutter, in 1JU 19554, attempted hindering prosecution in the first degree, do you want to amend your plea?
Yes.
How do you plead?
Guilty.
And in 1JU 2339, on count 4, criminal trespass, how do you plead?
Guilty.
And on count 5, unlawful contact, how do you plead?
Guilty.
And on count 7, unlawful contact, how do you plead?
Guilty.
All right, I find that you understand the rights that you've waived, that you've knowingly and voluntarily entered your pleas. I accept them. And based on the comments made by counsel, I do understand why the charges in 19554 were reduced. I do agree with the recommendations and the comments by the prosecutor in particular about why the sentence meets the Cheney criteria. So, Mr. Hutter, when I sentence someone, I have to make sure that the sentence looks at a defendant's rehabilitation, whether it's designed to deter them from engaging in that kind of behavior in the future, deter others, whether the defendant needs to be isolated at all, whether the sentence reaffirms societal norms, reflects community condemnation, meaning that more serious crime, people expect that more serious crimes will carry a more serious sentence. In your case, you have a terrible criminal history for violating court orders. You have violating conditions of releases, violating DVPOs, failures to appear, unlawful contact. All of those charges reflect your decision to violate the court orders. In connection with these charges, you're going to be placed on probation. You'll have a few conditions to comply with. If you choose not to do that, I have a year that I could impose for your decision to continue to not comply with court orders. Do you understand the consequences that you'll face if you decide to continue to violate your conditions of probation?
Yes, Your Honor, I do.
All right, in case number 19554, I sentence you to 30 days flat. There are some surcharges. These are not fines. They're surcharges that I have to impose in all cases. $100 police training surcharge, an initial jail surcharge of $50, which I'll make due in 6 months, and the cost of appointed counsel in the amount of $200.
Okay.
Because that's a flat time sentence, there's no probation and no probation conditions you need to comply with. In case number 2339, on count 4, criminal trespass, I sent you to 6 months with 6 months suspended. In count number 5, unlawful contact, I sentenced you to 6 months with 6 months suspended. In count 7, unlawful contact, I'll sentence you to 30 days. That's going to be consecutive to the 30 days that I just imposed in the other case. Again, those surcharges, $100 for the police training surcharge, $50 due in 6 months on the initial jail surcharge, $200 cost of appointed counsel. You would have no contact with Brody Flint. When I say no contact, that means direct or indirect contact, meaning you can't contact him through indirect means, not through friends. You can't send him messages. Don't contact him through social media. No contact in any way whatsoever.
For how long?
That's just a court order that you have to comply with while you're on probation.
That's fine, Your Honor. I don't have any problem doing that, but I do have a question. What happens if that victim, Brody, wants to contact me, which is more than likely when I get out of jail, he will want to contact me. What happens then?
I don't know if that was discussed, Ms. Wolstead.
He can let my office or your attorney or the court know, and we'll file something to modify that condition if he decides he wants contact.
Okay.
All right. In addition, was there an agreement as to the term of probation? 2 years. You are on probation for 2 years, sir.
Okay. Misdemeanor probation?
It's community probation. Obey all laws, federal, state, local. Comply with the sentence that I'm about to impose. Again, you're to have no contact with Mr. Flint, do not go to his residence. Obtain a substance abuse assessment and follow all treatment recommendations. And you're not to consume or be in possession of controlled substances.
Okay.
Did I miss anything, Ms. Wolfstead?
No, Your Honor.
Right. Mr. Hutter, do you have any questions about what we've done today?
I have one question. I've been in jail for, today is the 21st day. So you sentenced me to 60 days flat.
I sentenced you to 30 days flat because it's concurrent. Is
okay.
No, I'm sorry. If I'm wrong. Don't.
Okay.
Consecutive, 60 days, you're correct. You'll serve, I can't dictate how long you'll serve. It's generally about 2/3 of that time.
Okay.
As long as you have good behavior.
Okay.
Is that your question?
That was the one question, and then the other question was already answered by Ms. Wolfstead about Brody Flint contacting me.
Okay. All right. Okay. Did I miss anything, Ms. Wolfstead?
No, Your Honor.
Mr. Pulaski?
Nope. Thank you, Your Honor.
Mr. Miller?
No, Your Honor.
Okay, thank you, Mr. Hutter.
Thank you.
Your Honor, that's my only case for the day. May I be excused?
Yes.
Thank you. Bye.
Mr. McCourt? Mr. McCourt?
Yes. Yes.
Oh, you're on the phone.
Yes.
Okay, Mr. McCourt, stand by. I have to take the people who are at Lemon Creek first, okay?
Okay, no problem.
All right, next we have Mr. Sheldon. 1KU 17250, State of Alaska versus Jeremy Sheldon. All right. Mr. Miller, are you here for Mr. Sheldon?
Yes, Your Honor.
And which DA?
Bailey Wolfstead, Your Honor.
All right.
No, I'm here, Bailey. Sorry, I didn't chime in.
Okay, Ms. Kemp. Mr. Miller, the last we spoke, you hadn't yet had a chance to speak to Mr. Sheldon. You weren't sure how you were going to proceed. You needed time to talk to him. I advised that if it was going to be a contested adjudication, it wasn't going to be today, but you were going to let me know how you wanted to proceed. Have you had time to think about that?
Oh, yes, John. I tried to. I guess I haven't. We may have to postpone them because I've notified the state and they never got back to me that we would admit to all but one. And I was hoping we'd have maybe some type of agreement by now, but if not, we're going to have to contest one of the violations.
Okay. So am I scheduling this for a contested adjudication?
Apparently so. It would only be within regard to one of the conditions, but that's true.
So we don't have, this is actually my case, Your Honor, so I'm going to cover, this is Bailey Wolfstead. I am fine with not having a contested adjudication on that final condition, but I do believe we may need to set a time because we do not have an agreement on disposition. And so we're going to be arguing disposition. If the court wants to take the time to do that now, certainly we're ready. But there's not a full agreement.
Well, why don't I give you and Mr. Miller time to talk? I can put this on Friday.
That's also fine, Your Honor.
Mr.
And
Miller?
I don't think we're going to reach an agreement, but I think we should have I think there should be at least 30 minutes if we're going to have a... But sure, Friday's open for me, Your Honor.
Then I'm going to set it for 11 o'clock on Friday.
Does that work for you, probation officer?
I will not be present, however, P.O. Hutchings should be able to cover at that time.
Okay, thank you.
All right, Mr. Sheldon, we're going to see you on Friday at 11.
Okay, thank you, Your Honor. Your Honor, is that going to be... Oh.
Go ahead.
I was saying that will be a disposition as well, correct?
Yes.
All right, thank you.
Okay. I'll take Mr. Sheldon's admission, and we'll move straight to disposition on Friday.
Okay.
Okay. Thank you.
Thank you, Your Honor.
All right, Mr. Lee. 1JU16993. Okay, Timothy Ayers has not been with the PDs for about 10 years. Mr. Miller, is this your case?
Well,
Your Honor, this is Griffin. It's my case.
Okay. So, Mr. Lee needs to be sentenced. I think
That's right, Your Honor.
Pending. Ms. Wolford, is there any agreement?
No, Your Honor. If the court recalls, this is a case in which Mr. Lee had, it was either an SEJ or an SIS.
Yeah.
It was actually a case from before my time, and he failed that. He was pending sentencing, and Your Honor has had to issue multiple warrants because Mr. Lee kept not showing up for court. And then the last time Mr. Lee did that was fairly recently, I think back in January, and the court issued this most recent warrant. Mr. Lee had told us that he was going back to Huna and was going to call in, never did, and he was located here in Juneau and gave the police multiple false names.
I do recall. Ms. Griffin, have you had a chance to go over the pre-sentence report with Mr. Lee?
I have not had a chance to go over the pre-sentence report with Mr. Lee, Your Honor, but I think we're prepared to proceed anyways. Mr. Lee did want to let the court know, and I'm sure he'll have a chance to do that in a minute, but the hearing that was supposed to have been held to do this, when he was released and went back to Huna, he actually went to the Huna courthouse, and he was not able to get any sort of clear instruction about what to do. I don't think he understood about calling in. But anyways, unless Mr. Lee has something different to say, I think we should continue. We should proceed with this because he's looking at all suspended time sentence, and he needs to be released.
Well, then Mr. Lee's going to stand by while I finish everyone else. Because the court was not prepared to go on for a sentence, was not prepared to do a sentencing today.
Does the court want to set it over for tomorrow? Or we can wait, either one.
Just a moment. What time does district court have the polycom tomorrow? Does anyone know?
They usually do it at 1:30, Your Honor.
Chambers already has it at 10. 10 or 10:30.
And this is an SB 91 case, correct?
Yes, Your Honor.
It is, Your Honor.
All right, we're going to have Mr. Lee stand by. Let me take the rest of everybody else, and I'll try to get him sentenced today.
Yes, Your Honor. Thank you.
All right, Mr. Vanepps. One JU 151316, Jay Velasquez versus Stephen Vanepps. It looks like this was the time set for an adjudication, Mr. Miller.
Yes, Your Honor. My understanding is... Excuse me?
Mr. Pulaski is listed on as Mr. Vanepps' attorney. Are you his attorney?
Yes.
Okay.
And I believe Mr. Vanepps is prepared to enter admissions today.
Which DA do I have?
Ms. Kemp. This time I think for real.
So he's just admitting and there's no agreement?
No agreement, Your Honor.
So, Mr. Vanepps, what I have is a March 10th petition to revoke probation number 4 with 2 allegations. Do you understand what the factual allegations are in this PTRP? Okay. And it's your intention to go forward with an admission today?
Yes.
All right. And you understand you have the right to continue to deny them. The state would be required to put on a hearing, an evidentiary hearing, at which point they'd be required to prove these allegations against you, and you'd have the right to be represented by Mr. Miller to challenge the state's evidence, put on your own evidence, and continue to deny the charges, and you're waiving the right by moving forward with an admission today?
Yes, I am.
And do you understand, sir, that if I accept your admissions, then I'd be looking at imposing some or all of your suspended time?
Yes, I do.
You had enough time to talk to Mr. Miller?
I have.
Are you under the influence of anything today, sir?
No.
Has anyone promised you anything to get you to move forward?
No.
Threatened you in any way?
No, Your Honor.
As to the allegation that on 14th you violated the conditions of your probation by failing to report upon release from incarceration, do you admit or deny that, sir?
Admit.
And as to the allegation that on or about March 6th you violated the conditions of your probation by ingesting heroin, do you admit or deny that?
Admit.
I find that you understand the rights that you waived and that you've knowingly and voluntarily entered your admissions, and I accept them. Ms. Kemp.
So I don't know if Mr. Miller intends to go forward with the disposition today. I guess I'll ask him through the court if that's his request.
Mr. Miller?
I think we may want to try disposition at a different time. We can get on Friday as well.
I could put it on Friday, yes. Mr. Vanepps, do you consent to appear by Polycom at the disposition?
Yeah.
And is there a PO, is P.O. Herman still online?
Yes, I am.
Is that okay for you too, Friday?
I am not scheduled to be in the office Friday, but P.O. Hutchings should be able to cover.
Okay.
All right. And Mr. Sheldon, I didn't ask you whether you would consent to be by Polycom, but I assume that was the case on Friday?
Yes, ma'am, I'm fine with that.
Okay. All right, so Mr. Sheldon, we'll go 10:30 on Friday, your disposition, okay?
That sounds great, thank you.
And Judge Mead, one last thing, is it intended that the PO would give an oral update?
That would be fine. All right. Then anything else for Mr. Vanepps? I put it on for Friday, 10:30.
Yeah, okay. That's fine.
Your Honor?
Yes.
On Fridays at 10:30 is Polycom arraignments for district court.
Well, we've got Polycom. We need.
There's only one Polycom out here, Your Honor.
I understand that it conflicts with the Superior Court criminal block is the problem. Hold on.
I hear you.
What she wants to do. No, not real. Take care of Yep.
All right, let's move both Mr. Vanepps and Mr. Sheldon. Can we do 8:30, Officer Ely?
Yes, Your Honor.
All right, so we'll move both to, I'll just do them together at 8:30, starting at 8:30.
On Friday?
Yes.
I think you
Okay.
are.
Thanks.
And one last thing before we sign off here, Your Honor, what was Mr. Lee's next hearing? We didn't get that here.
Hold on 1 second. Well, that's because I'm going to sentence him in just a moment. I'm done with everybody except Mr. Lee.
All right.
Mr. McCourt?
Yes, ma'am.
All right, 1-2-20-51. Ms. McCauley, are you on the line?
Yes, I'm here.
All right, and Ms. Wolfstead?
Ms. Gibson.
Ms. Gibson. Okay, this is the time set for a bail hearing?
Did I think it's a status hearing?
I have bail hearing.
Definitely a bail hearing.
Okay. What are we doing today?
Judge, the request was going to be to have Mr. McCourt's van released to his custody out of evidence. And the reason for that is it's been difficult for him to comply with his conditions of release, being homeless and having his home essentially being held as evidence. I know that there are a number of other smaller items that are inside the van that he was also wanting to get. Unfortunately, I've been unable to reach sort of a resolution with the state concerning whether or not there would be a stipulation to release the van. And so I'm asking the court to consider releasing the van. And then just so that Mr. McCourt knows, I have been negotiating with the district attorney this week. Concerning your case, there's an offer in the case that I need to discuss with you. And of course, if the case settles, then the van would be, I believe, released to your custody.
So, Ms. Gibson?
Judge, the vehicle at issue here is the vehicle that Mr. McCourt used to drive to the location, which is a local church, on at least 2 occasions, and used that setup he had in that vehicle to siphon heating oil out of the tank that the church had. Suspected that Mr. McCourt has done this at multiple other locations, and he siphoned out, over $1,000 worth of heating oil in at least 2 trips, more likely multiple trips. And the way that Mr. McCourt and his vehicle were identified, at least one of the ways, was tire tracks in the snow, and the tires on the vehicle matched the tire tracks. Also, it's possible the van can be forfeited for its use of crime. I don't think that it's appropriate for the court to order its release in this case, since it is important physical evidence. I have been working with Ms. McCauley about the van. It's been, as she said, we have not reached a resolution, and that's why we're here today, Judge. But I think that it's very clearly material evidence in the case and should not be released at this time.
And can you, I might be misremembering. I'm certain that I don't have a full understanding of what it is I'm about to say, but I thought that there was a statute that provided for the release of evidence in certain criminal cases with a stipulation by defense. Am I remembering that incorrectly?
Judge, I think you may be... Oh, go ahead.
Ms. McCauley?
Go ahead, Ms. McCauley. Yeah.
Thank you. I don't know if there's a statute, but I do know that my client is willing to stipulate to a number of things, including he would stipulate that the tire tracks that were on his vehicle at the time of the alleged offense matched or at least appeared to match the tire tracks that the police were able to locate in the snow. I'm certain that there were photographs taken, but we are willing to enter into a number of stipulations in order to find a way for him to not be homeless.
So, Ms. Gibson, what were you going to say?
I was going to say that I think that Your Honor is thinking about a statute which allows the release of property that back to the owner of the property, such as if it's a theft case and let's say someone's guitar was stolen, the guitar could be released with a stipulation. But I don't believe, and Ms. Wolfstead is, I think, backing me up here via IM, that it doesn't force us to release evidence. And this is a little bit different than stolen property, as it's what Mr. McCourt, or something Mr. McCourt used to engage in and commit the crime. So I think that's the difference between the statute Your Honor is thinking of and the case we have here.
Your Honor?
Yes.
I would just wanted to add that I've been getting calls from the property or from the evidence officer at JPD asking me when I can come get my truck because the evidence that they needed to secure has been taken out of my truck and placed into electronic evidence, and the fuels related equipment that they seized as evidence has been removed from my truck, and everything that they needed has been taken out of it. And so they've called me on 3 or 4 different occasions now asking me if I can come pick up my truck. And the only thing that we've been waiting for, they told me, was to just have my attorney get a hold of the DA and get a release. And like as you said, or my attorney had stated, I have no place to live without my truck, and so it's imperative. I mean, it's almost imperative for me to have in order to keep on complying with my conditions of release.
Well, I do not believe I can force the prosecutor to, even with your stipulation, release the evidence. I understand what you're saying, sir, and you don't have any place to live otherwise. I really hate to see us forcing someone to go to the glory hall at this point in time, given the circumstances and how close everyone was to there, but I can't force the state to do anything different. So, if you, Ms. McCauley, if there's nothing else for Mr. McCourt, I think that the state's right, and I think that the statute that I was thinking about was 1236-020.
I understand the order, Your Honor, and I would just ask that Ms. Gibson consider talking to the evidence custodian at JPD to determine whether, in fact, they are trying to get rid of the vehicle.
Ms. Gibson?
I have been in touch with the evidence custodian, and it's up to the state whether or not we agree to release the vehicle. The issue with JPD is a bit different.
All right. So then it looks like, just so everyone knows, because of the statewide order that was issued today, Mr. Hutter, your April 8th hearing is not going to go forward. Your May 4th hearing, as it's already been set, that's the next time that you're actually going to be in court, is May 4th. Mr. McCourt?
Yes.
Did you hear that, sir?
Yes.
Okay. May 4th, and it sounds like Ms. McCauley needs you to contact her.
Yeah, I'm at this point, if the state ain't willing to work with me on getting my truck back, I'm not even interested in hearing any kind of deals. I'll just go to trial.
All right, well, I'll leave that to you and Ms. McCauley. And then an order will come out soon about the April 8th date. Is there anything else for Mr. McCourt then?
No, Judge.
No, Judge.
Anything else from the state?
No, Judge.
All right. Thank you, Mr. McCourt. All right. Turning back to Mr. Lee. Everyone, just give me a moment, please. Is this, whose case is this? I'm sorry, is it Ms. Wolfstead?
Yes, Your Honor.
Do you want to go ahead and make a sentencing argument for Mr. Lee?
Your Honor?
Yes.
It's LCC. If we're going to be going through with the sentencing, is it going to be a felony sentencing where we have to put fingerprints?
Mr. Lee has already provided his fingerprints.
Okay, thank you. Thank you.
All right, Ms. Gibson, go ahead, ma'am.
Ms. Wolfstead, Your Honor.
I'm sorry, Ms. Wolfstead.
Your Honor, what I am going to recommend is 18 months, all suspended, probation for a period of 3 years with conditions as in the PSR. You know, Mr. Lee was given a really incredible chance, a chance that most other people aren't given, and that's the chance not to become a felon, and he squandered that chance. And, you know, this is, I'll remind, I guess just for the record, the court, that this is SB 91 sentencing, and so, you know, he can't get actual jail time on this, which I understand going forward today. I'll note that he's got some history that is confidential. I know the court can look at it in the PSR. He certainly has a bit of adult history, a fair bit of it assaultive.